So what are the different types of will? These are the 6 types of will. The first will is conditional or contingent will. If a will has a condition attached to it, such a will is called a contingent or a conditional will. So suppose I say, if my son lives till age 25, he will inherit all my assets. And if he passes away before 25, my daughter will get all the assets. This is a condition. It's a very valid condition. And this will is a valid will. Right? So conditional wills are valid. Provided the condition is valid. Condition is legal. So suppose I make a will where I say that if my son marries a Hindu, he will inherit all my assets. And if he fails to marry a Hindu, he will not get even a pie from my assets. Now this condition is illegal because you are forcing somebody or restricting somebody to choose their partner based on religion, which is against the principles of the Constitution. So in such a case, the will is valid, but the condition is invalid. So your son, irrespective of whom he chooses to marry, will inherit the asset. He is not bound to marry a Hindu also only. But if the condition is valid, the will would only operate on the basis of their condition. The second type of will is a joint will. When 2 or more people jointly create a will, such a will is called a joint will. So me and my spouse create one document which we call our will. Me and my spouse jointly create a document which we call our will. Such a will is a joint will. Now, if this joint will is reciprocal in nature, so I'll give you some cases where joint will are made. First case is usually spouses. I'll just come to spouses. There's another case where joint will is made. Sometimes you own properties jointly. So you make a will joint for that property. I just told you can make as many wills as you want. Suppose you own a property jointly with your father, and both you and your father create a joint will for this property in favor of your, say, son. Such a will is a joint will, right? Now I come to joint wills which are reciprocal in nature. So me and my wife have made a reciprocal joint will, which says that after me everything goes to my wife, and my wife in the same document says after her everything goes to me. There we also mention that post the death of the survivor amongst us, post the death of the survivor amongst us, our wealth would be distributed in the ratio of 70:30 between our son and daughter. 70 to the son and 30 to the daughter. Now, the problem with such a joint will is that when one of the makers of the will, one of the testators who has created this will, passes away, the surviving testator cannot alter the will. Moment one of them dies, this will becomes irrevocable. Because a joint reciprocal will on the death of one of the testator becomes irrevocable. Because the law says when you two together made a will, there was a trust between you and me. It was the implied trust. And today, because one of the person who trusted you is not alive, can you break the person's trust? No. So a joint reciprocal will on the death of one of the testator becomes irrevocable. So should you make a joint reciprocal will with your spouse or not? What do you think? Should you do it or should you not? Why you should do it and why you should not do it? The reason of not doing is very simple. In a joint reciprocal will between the spouses and then to the children become assured of inheritance. Yes, my child knows he'll get 70, my daughter knows she'll get 30. Now, whatever we do, and one of them has died, so they cannot change the will. So, whatever we do with this person, we are bound to get this asset, and this person can do nothing about it. So, they become assured of the asset. So, they might care less for the parents. That is the reason why you should not do it. Right? And what is the reason why you should do it? Suppose after you pass away, your spouse remarries and has a set of children who are not your children. Now, if it is not joint reciprocal will, which is bound on her, maybe she will divide your wealth amongst your children and her children equally, which is not acceptable to you. Is that clear? So depending on what you think is more likely in future, you decide which type of will you want to do. A joint reciprocal will or a mutual separate will. I'll come to a mutual separate will. Right? And friends, in today's world, there is no age of remarriage and no age of having children. We have broken those barriers. That should be a concern. Now I come to a mutual will. Now I come to a mutual will. Mutual wills are reciprocal wills, but separate documents. I have created my separate document where I've said after me, all my wealth goes to my wife. My wife has also created a separate document where she says after her everything comes to me. Till here everything is fine. Now in this document I have to also write what if my wife passes away before me. So I say in case my wife passes away before me, my son will get 70% of my assets and my daughter will get 30% of my assets. Now she also has to write this. She does not agree with my way of division. So she says after me it is yours, but in case you pass away before me, 70% of it should go to my daughter and 30% only goes to my son. Now, till here everything is fine. Now let me tell you a very interesting case which occurred. The case was something like this. The story was something like this. There was this couple without children. In the previous case, whoever dies, it is not bound. The surviving partner could change the will. That's what mutual reciprocal wills have. So the survivor is not bound by the original person's will. I'm telling you a case where there was this couple without children. And both of them made reciprocal wills. in favor of each other. And then they said that in case one of us passes away before me, if my partner passes away before me, then my wealth would go to my parents equally. So husband says after me it goes to my wife. If my wife passes away before me, it goes to my parents equally. Wife has made the same will. After me to my husband, but there are no children. But in case my husband passes away before me, it goes to my parents, not to husband's parent. Right? So these two wills are in place. And both these people, the couple, they were traveling in that Malaysian aircraft that crashed. Both of them died. Now, whose parent get what? That's the question which came up before the court. So whom do you think would get what? Wife's asset to wife's parent, husband's asset to husband's parent? No. No. It's not so simple. So the reason is there is a basic law of property which says a property cannot be titleless, without title, for even a fraction of a second. So the law must find out which of these two people died first. If the husband died first, the husband would operate as soon as he died. And through his will, the entire wealth at that very moment passes to the wife. The husband's wealth goes to the wife at the same moment. And when the wife died later, the entire wealth, husband plus wife, goes to wife's parent. And if the wife died first, the wife's wealth is inherited by the husband, and after the death of the husband, it goes to husband's parent. Now, in such a situation, we are very clear what would happen. But in this instance, because there were no survivors, there was no way to find out which one of them died first. It is impossible to find which one of them died first. There also, there is a law to take care of this eventuality. And the law says, in case of simultaneous death of a reciprocal testator, where the timing of death or the order of death of the testators cannot be ascertained, the law would assume by default that the person who is younger survived the person who is older. And in India, who is more likely to be younger? The husband or the wife?
Wife is likely to be more younger.
Wife. So imagine that you have created a reciprocal mutual will with your wife, and because you have done so, all your wealth goes to your mother-in-law. Happy thought? Not to your parents, to your mother-in-law. A very happy thought or not? No. So for such situations, if you have your will made by a good lawyer, and here the word to underline is good, and that to lawyer, right? A good lawyer, they always add a clause which is called the clause of simultaneous death, where they say, in case, in the will it says, in case my spouse passes away within 6 months of my dying, then distribute my wealth as if I died the last. If this clause is put in both the wills, then husband's wealth would go to the husband's parents and the wife's wealth would go to the wife's parent. But how many lawyers in India would be aware that such a situation can arise in future? And how many lawyers know that there is a simultaneous death clause which can be added to prevent such a situation from arising? Estate planning, my friends, is a specialized field, very intricate field. And small differences, small mistakes made in the estate planning document cost very dearly to the maker, to the testator, to the person who's getting his estate planning done. So you should always get it done by a specialist estate planning lawyer. This is one place where the devil is in the detail. Devil is always in the detail. Right? A small word like on and after can change things dramatically. Actually, there was a will which came to for review to me where the grandmother wished that a part of her financial assets, that was some PMS of 50 lakhs, etc., she had, should be given to her 5 daughters for their marriage as a gift from her side. And the person who has drafted the will said that after my death, divide this PMS in five equal shares and give it to the daughter. And when the will came to me, I just changed this after to on, and I charged my fees to do that because after is indefinite, on is very definite. What would have happened if it remained after? The person who was appointed the executor would have kept the money with him till the marriage of the child and then given. And that would have created a rift between the brothers. When I say on the death, I said as soon as the death occurs, divide it and give it. Now no problem. So the drafting of the document needs to be very proper. It should be done by a person who knows this subject, who has seen it. That's very important. Okay. The fourth type of will is a sham will. Sham will is a false will. A will which is invalid, which was never meant to be valid. Let me give you an example. Suppose I am a person who has 2 sons, and one of my son is into the bad habit of taking drugs. Right? So substance abuse is his problem. And I am very concerned that I need to take him away from this and make him a better person. So one day I call my son who's into this habit and tell him that if you can remain drug free for next 3 years, I will give all my entire wealth to you through a will. And see, I have made this conditional will today. You can see it, which says that after 3 years, we will get you tested. And if the doctor confirms that you have not had drugs for last 3 years, you will inherit entire wealth of mine. Now this son becomes very motivated and he says, okay, I'll leave it from today. I'm getting so much wealth. Why should I Why should I continue this with this bad habit? And I give this will also to him. You keep this will also. Next day, I make another will, which says that yesterday I created a will which had given all my wealth to my son just because I want him to be a drug free person. I have no intention of implementing that will. And this will, which I am making today, is my real will, where I am giving it equally to the two sons. And if the son who is of the habit of having drugs continues to have that habit, the 50% share of this son who is likely to have this habit will be put in a trust, and regular payments for his survivorship would be made to him. This will I make, keep it with me, inform the executor about the existence of this will. Now, what happens to my previous will? It becomes a sham will. It was only made to motivate or demotivate somebody from doing something or not to do something. Such wills are called sham wills. And if my that drug son is lucky, maybe I don't survive that night to the next day, then that will becomes valid. And if you fear that, I have a way to overcome that fear also. What if you make that son who is into the habits of taking drugs a witness to the previous will? Then anyhow he's out, right? So okay. So devil is in the detail. More you know, more better you can play the game. Okay. Now we come to holograph wills. Holograph wills are handwritten wills. Wills in your own handwriting. Holograph wills are the most difficult wills to challenge in a court. Because there are two reasons why people challenge a will. One is the signatures were taken fraudulently. This person never knew he was signing a will. A paper was put in front of him, he just signed it. Second is, this person was not of sound mind while creating a will. If I have handwritten will of 4 pages, then you cannot say signatures were forged. For the entire will is in my handwriting. How can the signatures be forged? Second, if I am capable of writing a 4-page document in my own handwriting, my mind is sound. Even if somebody is dictating this content to me and I am just noting it down, I have the mental faculties to listen and put it on paper. And that is all that is required to make a will. So holograph wills are very, very difficult wills to challenge. And the only problem with holograph will is your writing should be clear, should be understandable, should be legible. The last will is oral will. Oral wills are spoken wills, not written wills. Oral wills are spoken wills, not written wills. So in India, oral wills are invalid. Only 2 types of people in India are allowed to create oral wills. Otherwise, it's not. They are invalid ab initio. They are not valid at all. Who are these 2 people who are allowed to make oral wills? Number 1 is defense personals. At the time of action, can create an oral will. A soldier goes to a terrorist operation and he thinks that he will not survive. He tells his colleague that I think I might not survive and this is how I want my assets to be distributed after my death. This will is an oral will and it's a valid will. Provided that colleague who has listened to this puts it in writing within 3 months of this person dying, this will becomes an oral will, no witness, nobody. It's a valid will, right? So it's a privileged will given to defense personnel. And remember, I have said defense personnel. I have not said army, navy, or uh, air force people. So even your BSF people, your other people who are into it, well, not police, but central forces, they come into it, right, at the time of action. Second people are merchant navy officials. The ship is sinking, they tell their colleague, if they don't survive, this is how it's allowed. So apart from defense personnel and merchant navy officials, the second group of people who can create oral wills are Muslims. The Muslim law allows oral will. A Muslim can cancel his written will by oral will. So Muslim has made this 1/3 will. At the deathbed, he says, I cancel that will. And instead of this, do this. Provided somebody can prove it, that will is valid. And the original will gets, the written will gets invalid. So any questions anybody has on kinds of will?
The question is on the oral bills, how it can be proved that it's said?
The onus of proof is on the person who is benefiting from the will. They might put witnesses, they might have some recordings done of it. That's the way to prove it. So it's not a suggested way of creating a will. It's not a good way of creating a will because proving is difficult. But sometimes you have no other option. So in that case, if the proof is made and the court is satisfied that this will was made, they would say that this is the valid will. They would not invalidate the will just because it was an oral will. Because they are allowed to make that will. Right?
Okay.
Witness confirms that this person was told this will, and because this person was not in a position to sign the will, somebody else has signed on his behalf. Witness is confirmed.
A will on simple paper is also valid?
So let me tell you 3 big misconceptions about a will. A will need not be made on a stamp paper. A will need not be registered. And a will need not be typed. All 3 of them are optional in the case of a will.